Hello and welcome to Legally Speaking with me, Tarun Nangia. Today we're going to discuss uh, an order of Justice K.V. Vishwanathan and Justice Jamshed Pardiwala. Very important. They have flagged something deeply concerning with the India's insolvency framework, uh, which is that the resolution plans, which are meant to revive companies, are today pending before the NCLT for years. And this raises a fundamental question, that is the IBC built on the promise of speed now breaking down at the final stage of approval? Because if a plan approved by the COC remains stuck indefinitely, COC is the Committee of Creditors, the entire objective that value will be maximized, investor confidence will be maintained, and time bound resolution all stands defeated. So now the Supreme Court has gone a stage further. Justice Pardiwala, Justice Vishwanathan have sought nationwide data from NCLT and the Insolvency Bankruptcy Board of India on the pending resolution plans. And are we seeing a beginning of a larger judicial intervention on the systemic delays that the National Company Law Tribunal has been witnessing? And this structural crisis, finally, is the Supreme Court moving in to solve this? We will decode this on the show today. I have a stellar panel with me. I want to welcome Senior Advocate Percival Bilimoria, Senior Advocate Vivek Kohli, Advocate Divya Agarwal, who's Senior Partner at JSA. Good to see all of you and thank you for your time. At the outset, I want to request Divya Agarwal to give an explainer on this subject, and after the explainer, we'll delve into the debate. Over to you, Divyam, for the explainer.
Thanks, Tarun, and thank you for having me. I'll begin with a quote from George Canning. He's a former Prime Minister of UK. He once said that indecision and delays are the parents of failure. And that is what really sums up today's discussion. I think it is important, Tarun, to acknowledge what is now a settled paradox. On one hand, IBCs being one of India's most consequential economic reforms. In fact, it has transformed creditor rights, improved creditor discipline, materially enhanced recovery rates. On the other hand, the system today is visibly strained by delays, backlogs, and endless hearings. The concern flagged by Justice Pardiwala and Justice Vishwanathan is therefore not merely procedural. Okay, it goes to the heart of value maximization, which is the central objective of the court. If you even read the statement of object and reasons of IBC, it is a timely manner. The words used are timely manner, value maximization. The entire purpose is lost. And let me give you a couple of data points to establish what I'm saying. Currently, 76% of the CIRP proceedings are exceeding 1 year. 56% of that exceeds 3 years. The statutory limit of under IBC for a corporate insolvency resolution process, CIRP, is 330 days. Guess what is the completion time, average completion time? It's 853 days in the last financial year. That's like 150% deviation from the prescribed timeline. Okay, now what is the consequence of this? Let's not look at these numbers in abstract. What is the consequence of it? There is 30,600 pending cases in NCLT. Approximately 10 lakh crore of distress assets are locked in these proceedings. 10 lakh crores. Let that number sink in. At this disposal rate, we are looking at this 853 days going up by years and maybe a decade sooner or later. So it's not just delay, it is value erosion. By the time some of these companies reach the level of resolution plan, the business is no longer viable. The asset has eroded to an extent that it is no longer valuable for any resolution applicant to come in. I mean, you'll see instances where resolution applicants have backed out, saying that I don't think the asset is, or the company or the business is worth anymore because of all this delay that has happened. But let us not simplify it by simply saying that the delay is only at the stage of resolution plan. In my experience, the delay is at every stage. Okay, there is a pre-admission stage where there is a delay because a lot of cases have been filed. We all are aware of it, which is essentially done to recover money. Okay, and therefore, when you sniff out those cases out of the lot, it takes a huge amount of time. I mean, again, statistically, CRPs that have been admitted in the last many years, it is 8,600 approximately. The pre-admission disposal, which means the cases which did not make it to the CRP stage, is around 26,000. So every fourth case is what, I mean, out of four cases, one is getting admitted, literally. That's the rate we are looking at. So there is a delay at the admission, pre-admission stage. Then there is a delay at the level of the resolution professional. Okay, the law clearly prescribes that the resolution professional is supposed to be a sort of an overseer of the entire process. Even there has been amendments in the IRP regulations which clearly define them. They have to act within statutory timelines. But the difficulty is that there are some very complex businesses which has been taken over by resolution professionals who don't have that experience, who don't have that capacity or expertise to run those businesses, or to at least handle them in a proper manner. Then there is a delay at the time of constitution of COC, at the time of acceptance of claims, going through the company record. Sometimes the promoters are not, or the erstwhile management is not allowing access to the resolution professional. He's again running pillar to post. Then there is excessive deference towards the COC. Whatever COC says becomes the final norm. So there is again a delay which is riddled at that particular stage. Then comes the stage of committee of creditors, COC. There again, I hate to generalize it, but the COC being the decision maker, the objective remains that whatever best the COC or the whoever is the final decision maker in the COC, whatever best that particular company or the creditor can make out of the process. There is a reluctance of taking haircuts. There is always a interstate dispute between the COC members, the financial creditors. Informal negotiations keep happening in between. There are some litigations which keep coming. There is even a disagreement on distribution of waterfall. So all these issues at the COC level again results in delay. In fact, I remember there is a decision of Supreme Court of EBIX Singapore, if I recall correctly, where they clearly said that permitting modifications, withdrawals, or post-submission negotiations outside the framework of Section 12A is totally unregulated. That it is inevitable. It's going to cause delay in the CRP. But again, we keep facing those issues. Now, let me also identify, before we go to the resolution plan, let me also identify one more issue, which is, I would say, more of an administrative or an infrastructural issue. The NCLT right now, there are 16 benches, okay, and 30 courtrooms. 24 out of the 30 courtrooms are operating on half-day schedules. It is not just limited to IBC. They have company law matters. They have mergers and acquisitions. They have operation mismanagement. So imagine the 30 courts running almost half of the time they have, half of the strength they have, and riddled with other set of cases as well. That kind of a infrastructure, that kind of a constraint which they are working in, let's not just put the entire blame on NCLT. They have their inabilities, which is riddled by the fact of the infrastructure issues, I mean, the constraints they are facing right now. Plus, there is, of course, now let's also come to the fact that where at the NCLT level the problem happens. NCLT, I mean, we have seen, and it's quite unfortunate that they get into the judicial review of the wisdom of COC. Time and again, Supreme Court has made it very clear. COC is the final arbiter, the decision maker. Their wisdom has to prevail over anything. But then the NCLT at its level, adjudicating level, they sit on it. They'll try to judicially review it. Again, that in my experience, that further results in delays that comes out. when they get into the documentation of the resolution plan, they realize what is the feasibility, what is the viability, whether unsuccessful bidders or operational creditors have been taken care of. I mean, a lot of ambiguities are created, a lot of inefficiencies are crept in when you get into this mechanism. They are supposed to be a watchdog, so to say, when it comes to this process. Once the COC has taken a view, so long as certain parameters which have been well defined in our judicial system, once those parameters are met, they must be allowed to proceed further. I mean, look at this fact that by the time the case reaches at the stage of resolution plans, years have already passed. And then on, I mean, insult to an injury happens when that resolution plan is put to task before the NCLT. NCLT takes a fine lens and starts reviewing it threadbare. So that together, all these issues, I would say, is what's gripping us. There has been an amendment which has been introduced recently, which tries to systematic reduce these delays. There have been accountability created for NCLT, why they have not admitted the proceedings under Section 7, 9, and 10. The clauses have been added that within 30 days of the resolution plan, you are supposed to move forward. So the point is that legislatively it is accepted that there are issues which are being pending, which are crippling this entire process. There have been ways to identify it, but the system entirely requires an overhaul. And I totally subscribe to what Justice Padiwala and Justice Vishwanathan is trying to do here, and I'm all up for it.
Thank you for that explainer. I'll go now to senior advocates for the arguments and commentary on the order. Senior Advocate Percival Belimuri, I want to bring you in here. How significant is this order passed by Justice K.V. Vishwanathan and Justice Jamshed Padiwala, which is now seeking nationwide data of resolution plans? And where is the court heading?
I think it's very significant. So, see, DVM pretty much summed it up. I mean, the delay is not so much, at the NCLT level, although the order is, of course, focusing on the delay at the NCLT level, right? The adjudicating authority. So, there is a provision in the law that said that you must decide within 180 days, extendable by 90. There was an amendment that said that at the most, mandatorily 330. Now, the difficulty again is that in, 330 was, according to the amendment, to include any litigation. So, I mean, it can't be that you have a deadline in the law and, under the Limitation Act, any time that may be spent on some issues in a court of law or before any forum are excluded for computing that timeline. So this amendment kind of fixed that. But then in SR Steel, a three-judge bench said that, look, we think that mandatorily could probably take away the rights of litigants. And see, to argue, see, the thing is that in this country, very rightly so, anybody can file anything, right? Because you have a right. If you are a interested party, you have to stand up and say, listen, I object to 1, 2, 3. Now, the difficulty, of course, is that this is misused because sometimes people will just say rubbish and then, their application will be admitted. The moment an application is admitted, it has to be replied to, and then there's a rejoinder. So, I think some wise counsel, would be good. And, as Divyam rightly pointed out, I mean, I remember there was a decision of Justice Nariman, and time again, people have said that COC is their decision cannot be interfered with. It's not a judicial review because they are the people who will inherit the distress asset. Now, it's not like, for example, BIFR. In BIFR, one would go there and try to convince the bench that, look, this is a scheme which will revive the unit. Here is a person who has come forward to, with or without haircut, to say that, okay, I will revive the unit. and that's the resolution plan. And in their commercial wisdom, they have done it, and the shareholders have accepted it by supermajority. Now, to have judicial or technical officers sit in review over that, I think it's a little bit of a stretch, and that adds a lot to the time frame. But ESA still clearly said that, look, we will take away the mandatorily because we do not want this to result in a denial of somebody's right to raise objections. It would be a violation of Article 14. Now, the issue also is that this continues to result in long timeline before NCLT. And the result is that we are not achieving the ultimate objective. See, the objective is liquidation is the last resort, right? So Divya mentioned erosion. Now, suppose a resolution plan is submitted, if it is not approved in time, 180 or maximum 30 days, or at the most 330 days, right? And for whatever reason, it carries on and on. The point is, doesn't the plan become stale? See, consider yourself as the person who submitted the plan, right? You have valued the assets, you have projections there, in terms of, what would be the right price for any of these assets, etc. So there is a entire scheme that has been formulated. Now, does that scheme, the proposition in that scheme, continue to remain valid forever? It doesn't. So in real-time commercial world, you cannot have a situation where a resolution plan carries on and on. So this is a big issue, and I think the bench must be commended for all that they've done. Is let us look into the reasons. They've invited some data. As Divyam said, there is I think a finance committee that has already produced data where 71% of the resolution plans have been delayed beyond the statutory time limit. But it would be a very good situation for the bench to review what is happening across all the NCLTs all over, and then inquire into the reasons for the delay and then lay down the law.
Thank you. Thank you for bringing that insight, Mr. Bilimoria, into the discussion. I'll go to Senior Advocate Vivek Kohli. Mr. Kohli, what are Justice K.V. Vishwanathan and Justice Pardiwala hinting at? See, both are going to become the Chief Justice of India. So the view that they take becomes very important because they will be in a position to do something about it. Are we seeing that they're indicating that they're going to reform the IBC? We are seeing those indications via orders like these. Where are we headed at? And in your view, what should be done? What reforms should be done so that this process, as the Supreme Court has now indicated, is set into the right motion as the framers had envisioned it? Yeah, you're muted.
Thank you, Tarun, for having me over on this show. So let me start by saying I think it's a salutary order, possibly triggered by, for the amendment which has just been passed with respect to the IBC. And if you see that amendment, there is very little it does addressing the issue of delay. So as far as that aspect is concerned, it's completely blanked out in the amendment. Now, this could possibly be a trigger for the court to step in and say that, this is something which is afflicting the entire system. What are you doing about it? Apparently, the legislative arm seems to have ignored it completely. Now, let me just put it in a slightly, I'm sorry if it sounds cynical, but in a slightly different manner. The act was made effective in December of 2016. We are less than 10 years in. And in 9+ years, we managed to create a backlog of more than 9 years. Now, it looks kind of strange to me that this is something which is, recent, only 9 years back, with all the wisdom that you've, sort of achieved in the last 70 years of independence. You could have done a better job. You chose a platform, you chose a forum, and let's just for a moment analyze what you did with that forum. They were already looking at company matters. It is one of the most important jurisdictions of this country. I mean, ultimately, if you look at just the figures relating to corporate tax, if you look at the amount of employment that is created, direct, indirect tax, everything, if you look at the corporate part of India is absolutely the most important part. And this is the most important jurisdiction. Now you load it up with IBC, which is the natural choice of a forum. Let's go on the structural things first. 63 members sanctioned. What is the vacancy level? More than 35%. The vacancies is something which we specialize in. In every judicial forum of this country, we are running vacancies in excess of 25-30%. As it is, our ratios of judges to litigants is absolutely pathetic. And after that, we manage, vacancies. And in the vacancies, I mean, the serving members, as Divyam said, don't have infrastructure to sit in. How do you expect? I mean, 30% vacancy, and then you have 50% of the courts defunct. Really? And this is the most important jurisdiction possibly you have, apart from the constitutional one in the country. I mean, what's the government's vision on this? What exactly are we kind of trying to achieve? That's one part of what you're doing. The second part, the most important aspect, if you see the pre-admission delays that are happening, those can be addressed if you have proper infrastructure, proper members, and you are able to, they are able to sniff out what is the recovery proceeding and what is a genuine insolvency proceeding. Fact of the matter is that today, much of the proceedings in the NCLT are, camouflaged recovery proceedings. It's leverage. If I get you admitted, you're done and dusted. The 12A points Divyam made, even after admission, side deals are happening. People are saying that, "Acha, mera settle ho gaya. I'm now going to withdraw." That wasn't the intent. The intent was that if the company is not functionally viable, then there should be a change of management, and whatever is the best course for survival, revival, that should be followed. I don't see that happening. This is more like leverage now. And you have to have solid members in the NCLT who are able to sniff this out in adequate number, and then the admission stage delay can be addressed. Come to the CIRP. The most important pivotal point in the CIRP proceeding is the RP himself, the resolution professional. He's the one who takes over the company. He becomes the management, takes it over as a going concern, keeps it running in the minimum, as Percy said, for 330 days. Abhi there's no experience that anything gets done before 330. It's 852, as Divyam said. Now, for a moment, just step back, Tarun, and think about how important the resolution professional is. And please just have a look at the legislation on what is the qualification to be a resolution professional. Do you need a team? You're taking over running businesses with hundreds of employees, and one man goes and sits there. What's your competence to run this business? What's your understanding? What are the factors by which you choose a chartered accountant to run a steel business? I mean, that gap in my mind is baffling. Many times I think maybe I should go and practice medicine. Chal jayega. I mean, does that make sense? It can't work like that. No, there has to be some symmetry in what is the talent which is available and what is the job at hand. There has to be some symmetry there. And that is where possibly the NCLT playing a role makes sense. Because whoever files a 7 or 9 is the one who actually comes out with a proposed resolution professional. He is the one who gives the name. And let me ask you a question. Don't answer it, but just think about it. If I'm filing a petition, whose name will I give? Whose name will I give? And you think I'm going to give the name of the most super competent person to run the industry I'm going after? No. How do you deal with that? That's where the NCLT needs to look into it. What do they look at that point of time? Has he given consent? And is there conflict? That's it. Let's move on. And they are very concerned. What are the contours of the resolution plan? Let me ask you another question. If the person producing the resolution plan, filing it before the NCLT, is himself not the best person, what is the result you'll achieve? I mean, it's basically, the team that is performing which produces the result. If the team itself is like, sort of, you'll end up at the bottom of the board. No, kya karoge aap usme? There's nothing much that you can do. But that's the point at which they should be paying attention. But they are paying attention, as both the gentlemen said, post the COC. Abhi we'll check the wisdom of the COC. It's their money. The concept is it's their money. They'll figure out how to handle their money. Trust them with their money at least. Pay attention to the more important things. I don't know, but at least I hope that with this order, both the Supreme Court is actually able to look at what are the learnings over the last 9 years and possibly set out to, correct this entire IBC framework to make it absolutely the model framework on how future dispute resolution in India should happen. We have a massive problem in arbitration. Constitutional courts are blocked. District courts are, completely burdened. Pull out one model, make it, at least make it functionally the best there is, set it up as an example so that everybody else can follow it. I hope the Supreme Court does take this up as a test case and follows it through to make it into that ideal system, so that the learnings of the last 9 years results into something meaningful.
Thank you. Thank you for those stellar points that you brought in, Senior Advocate Vivek Kohli. I'll go to Advocate Divyam Agarwal from JSA. Divyam, what happens to the value of stressed assets during this period of delay? In some cases, maybe like commodities, it may go up because it's a cyclical business. Otherwise, what happens to these assets during the period of delay?
In my experience, most of the time I've seen the assets getting deteriorated, whether it's a real estate land parcel, because of the structure that has been created, such has been lying there. The land is not put to proper use. There have been instances where industrial products have again having a shelf life. Let's in fact look at it as an example. I mean,
Or market share.
Yeah, or a market share, correct. And let's look at an ideal world example. Right now, the world is having all these conflicts. When, let's say, I am into building of drones, or I'm into building of some defense equipment, right? If this is the time for that particular corporate debtor to be in the play, right? As I said, it's an ideal world. Let's hope peace comes in soon. Once the peace comes in, there is no need for this product. Possibly, market is already filled with so many products that your product becomes insignificant. So, I mean, my experience says time is of the essence. Most of the cases, what's happening is that the resolution is getting into liquidation and the opportunity is getting into an obituary. That's the fact right now. So we must value preserve, value maximize. As I said, the statement of objects and purposes of IBC says value maximization in a timely manner. And if we miss that bus, then that's unfortunate.
Point very well taken. I'll go to Senior Advocate Percival Bilimoria. Mr. Bilimoria, do you think that resolution applicants in many cases, once their plans get stuck, they even lose interest in the asset beyond a point?
Yeah, absolutely. I mean, because as I said, the original concept of the plan, it gets outdated. And then it's very natural for them to say, well, maybe we need to rework this entire scheme. And then the issue is that you cannot modify a plan. Once it is submitted, it remains. So therefore, it becomes stale. And, I mean, they may have to do some rejig, but they cannot do so legally. It has to be approved. So that's a very difficult situation for them. And you see, there are several other implications of delay. So, for example, there's the moratorium. So the creditors, while the CIRP is going on, the creditors cannot proceed. Now, so that results in acute working capital shortage. Some MSME units, etc., were supplied material to these companies. They will suffer because they cannot even take steps to recover because of the moratorium. And the longer the delay, the moratorium also gets extended. So, but look, if you were to take an overall picture, right? I mean, see, there are two kinds of sick companies, Tarun. One is where the company is genuinely sick because of certain economic factors, right? I mean, see, not every business is successful, and the, I mean, in a good market-driven economy, if the company is not successful, what they call as creative destruction. It should either be taken over by somebody and best of luck to that person, or it should wind up, because that will then free up the resources that are locked up in distressed assets, and then you reinvent yourself. The other kind, unfortunately, is where capital or money has been siphoned off. See, it is no, it's no, not a question of chance that many of the companies who are in before NCLT nowadays undergoing CIRP are real estate companies, builders. And in almost every case, you will find allegations of siphoning off of money, right? And, preferred creditors. And I mean, some ingenious schemes. I think, my friend Vivek knows what I'm talking about. So you come across some ingenious schemes which builders devise to, to make money. And that's a very unfortunate part. And I think the courts have to come down very heavily on such companies, because that doesn't serve any purpose. So the other, of course, you can look at more liberally, but ultimately the proof of the pudding is in the eating. See, ultimately, this is the one law that has really revamped the entire process. Because until now, SARFAESI, recovery of loans, BIFR was, I remember in 85 when it was brought in, we all thought that, oh, Mr. Gandhi has done a miracle here by, trying to actually look at reviving sick units. But it never worked, because people kept on looking at the plan. Will it succeed? Will it not succeed? I remember there was a company, Calcutta company, a huge multinational. They were sitting on tenanted properties worth millions of dollars, right? Because in Calcutta, Bombay, you have this, issue of, if you're a tenant, then you will never leave. And, most of those properties were sold off at huge premiums, which are not even on the books. And the reason for that only was that they managed to keep on the BIFR proceedings. They managed to drag it on and on. And this is the first time that this innovative law that was introduced, and to some extent, it has also been successful. There have been many success stories, right? And which have at least reduced NPAs of the banks. But it still has a long way to go, and it is in grave risk of deteriorating back to another BIFR.
Very succinctly put by Mr. Belimoria. I'll go to Senior Advocate Vivek Kohli. Now, when you advise a party in the case or a client, has it become necessary to sort of advise them on the delay possibilities in the case? Has that become one of the key aspects when somebody is getting into this kind of a litigation?
So, Tarun, this is not something which we need to advise. This is one of the first fundamentals. Divyam will tell you whenever a client comes to you, the first thing he says is two things actually. The first he says is, what are the merits of my case? What are the chances? And every person would want professional advice on that. The second question they ask is, how soon? Or what is the timeline in which I can get that result? Now, the first one, most of us are able to answer. The second one is really a dart on the board here. I mean, it could be anything dependent on which bench at what time aapka, I mean, how efficiently is that working? It's really sort of a mystery. Kitta jaldi hoga ya kitte, but putting down a timeline, almost impossible. And now there are two consequences of this. Once they are unsure about the timeline, the first thing they say is, do you think it's better if I settle? Which means essentially he's made up his mind that I can take a haircut. I don't want to get into the jhanjat. Now, which is like, sort of a very sad commentary on the legal system, because the legal system is actually a deterrent to, sort of pursue your rights and is encouraging you to settle kar lo. That by itself is like, sort of a sad comment on the legal system. The second bit is, the point both the gentlemen made on the value part of it. Now, when a plan is approved, there are many stakeholders. It's not just the resolution applicant. The banks are taking a haircut. The vendors are saying, okay, fine, whatever, I'm getting 10 cents to a dollar or I'm getting 50 cents to a dollar, at least the money comes now. Now imagine the plight of a homeowner who thinks I'm going to get the flat, but he doesn't get it for 2 years. It's a cyclical market. Now, in 2 years' time, if the market goes down, the resolution applicant will be crying. He'll be complaining that, this didn't work out for me. I want out of the resolution plan. But as Percy said, there's no really way out once the COC has approved it. On the other hand, the creditor, whether it's a financial or operational creditor, he is now waiting for 2 years, and if the market goes up, then the risk he has allocated to himself, the equilibrium of the deal which he had approved at that time in the COC, that equilibrium is gone. Now, the risk allocation time is deciding. You are like on a Russian roulette system, no? Time is going to then decide how much you're going to get or what you're going to get. It could turn out well for you, it could turn out badly for you. But that's not really, see, law is premised on two things: predictability and consistency. Absent these factors, really, if the law keeps changing or the interpretation keeps changing on the level of the forum, then there's no consistency or predictability. What will I do? I'll never go to the legal system. Or if I go and I don't know by when will I get out of, the input is there, but output kabhi aayega, I don't know. Where am I going to go? Why will I go? So, you have to set the system right for it to be able to deliver whatever your intent was. And the intent was a fast, one-stop shop, value not eroded, conserved resolution.
Indeed, and that is what I think Justice K.V. Vishwanathan and Justice Jamshed Pardiwala are getting at, I think, with this order. And as rightly put by Senior Advocate Kohli, we don't need to drive out people from litigating by our actions. It is imperative to litigate at times, but by the kind of slowness in the system, we don't need to push out people out of the litigating process. It impacts a lot of lives. I think we're completely out of time on this one, so we'll take the pending issues on the next show. I would like to thank Senior Advocate Vivek Kohli, Senior Advocate Percival Bilimoria, Divyam Agarwal, Senior Partner at JSA, from very good points made on today's show on this order by Justice K.V. Vishwanathan and Justice Pardiwala. And I think this will give food for thought to many. Thank you so much for coming in on this one. Thank you.
Thank you.
Thank you.